All right, we are back on Morning Line. Thanks for joining us. Nick Barris here. The number 737-7587 if you want to join in the conversation. We're waiting right now as we electronically try to link with all of our guests in this COVID pandemic on Zoom. And John Harris with the Tennessee Firearms Association in the process of hopefully getting that up and running in a moment. And as soon as he links into us, we'll take him live and talk about some of these gun issues. And that's one thing that I wanted to bring up as we all watched and covered the story, not this Saturday, but the Saturday before in downtown Nashville, as you had some of the looting and some of the rioting that came out of what was essentially a peaceful protest on a very important cause and raising awareness on equality and all that. But then as it came after dark, what happened? I just remember watching and thinking, gosh, what's going to happen is they make their way to the courthouse and try to burn that down, and then they make their way down over to 2nd and Broad, and you see them hitting a number of businesses. What are individuals' rights when it comes to weapons? And we can check in with a lot of people on that, but one person who certainly is, I think, very up to speed on what you can and cannot do in regard to self-defense is John Harris, who does now join us live. Good morning to you, Mr. Harris. Thank you for joining us. Can you hear me loud and clear?
Yes, I can hear you fine.
Ah, good. And we've got a good connection with you. Thanks for joining us. Yeah, I was about to just lead into that. I know you, like a lot of other people, probably watched, a couple Saturdays ago, and as that looting occurred and started, and they went into various establishments there, I think to some degree they caught a lot of people by surprise. But I had more than a few people contact me with messages on Facebook asking, all right, Nick, what's the situation? What if there was a merchant who was there, who saw this coming, and, is legally armed with a weapon, and he's inside one of these businesses when some of these looters break in? What are the rights of those individuals when they break in, if you are the owner of a business there, to defend yourself and your business? And where does the line come where you have the right to use deadly force in that instance?
Yeah, that's a great question given what we've been through for the last couple of weeks. And unfortunately, it's not a question that's got an easy answer. In Tennessee, we have a specific statute that addresses when you can use deadly force as a civilian. And that statute says, essentially, that you can only use deadly force if there's imminent fear of death or serious bodily injury to a human. So there's got to be a physical threat that's pretty severe directed specifically towards an individual. What our statutes don't allow is the use of deadly force to remove a trespasser, to stop property damage, or to stop a property theft. If it's only a risk of property or trespassing, our deadly force statutes in Tennessee don't allow you to resort to deadly force, which can be something as minor as brandishing the gun or yelling, stop or I'll shoot, and displaying the weapon. You don't even have to discharge the weapon under Tennessee law to actually use deadly force.
Is that different when we're talking about an establishment? You and I have discussed before the Castle Doctrine, right? Is that different where if you're in your home, or as you've said now, it's extended to someone's vehicle, where if someone tries to break in, you can shoot them? Is that different than, say, Margaritaville on 2nd and Broad?
Not necessarily, but the same basic standards happen. What happens with the Castle Doctrine, that's a term that we hear a lot, but I don't think it's really clear, and there's a lot of confusion about it. The Castle Doctrine basically in Tennessee creates a legal presumption that's applied at a criminal trial that under certain circumstances, someone is presumed to have had imminent fear of death or serious bodily injury. And those circumstances are that the person has a situation where they were in a place where they had a right to be, so they were in their own business establishment, that a third party forcibly and feloniously entered the property, which might be a looter breaking in to the property, and that under those circumstances, there would be a rebuttable presumption that arises that imminent fear of death or serious bodily harm is available that would justify use of deadly force. The problem is that it's a rebuttable presumption. So if the looter comes running through the door and they start a fire and leave, or they steal a bunch of boots and they're leaving, the district attorney might be able to overcome that presumption and say, although the presumption applied initially, once they started to break off and exit the property or turn to run away, you were no longer in imminent fear of death or serious bodily injury, and therefore you actually commit a felony in Tennessee by using deadly force under those circumstances.
Interesting. So it seems to me what comes into play here are two things: the timing of when perhaps you take steps to defend yourself, and maybe, as best as you can share it with investigators, what your perception was. Because I'm imagining if I'm a store owner and I'm on Lower Broad and I'm there and I know they're coming perhaps because you hear it, and I'm sitting there with a weapon, and all of a sudden the front window shatters and they come running in, okay? And this is before they grab anything, but they run in. At that moment, I'm going to be frightened, okay? I think anyone would be frightened at that moment. And before they turn and grab anything, but they've just charged into the store and they're coming maybe toward me where I'm standing, and I shoot them because I fear for my own safety at that moment. They haven't grabbed anything to leave yet, and I understand you can't shoot them in the back as they run away. So in that scenario, do you have a leg to stand on?
If you can make the case as a defendant in a criminal matter that you were in imminent fear of death or serious bodily harm, that the attack was still directed towards you or someone who you had a right to defend, then the self-defense principles would be presented to the jury for them to decide was it self-defense or not. Where you cross the line is and this is an easy, unfortunately, easy line to cross, is the problem that a property owner runs into, particularly a business owner, where they're really defending the physical space.
Yeah.
And they're defending their inventory, or the person has snatched something and they're starting to run away and they yell, "Stop or I'll shoot," or they give chase with the weapon to try to stop a burglar. And that constitutes not deadly force based on imminent fear, but the use of deadly force to stop a property crime, and that's a felony in Tennessee.
I gotcha. I mean, when you hear it that way in the wiggle room, and I know some people are going to say that's ridiculous, other people will say, yeah, you're not supposed to kill someone on a property crime. But you're a lawyer, and I did some checking on my own. I don't know if you know. I know you don't sell insurance, but in damage because of looting and rioting, I don't know that all insurance writers cover that for businesses. Do you?
Well, there's a gray area there as to whether or not that would be just a burglary, or if it rises to some higher level that falls within the insurance exclusions. Okay. So it's going to be an after the fact decision by adjusters and investigators as to whether it was a covered claim or not. And you know, when you bring up insurance for these business owners and civilians who've been through what we've seen now in the Nashville for the last 2 weeks, is there are actually certain types of programs out there. I don't want to call them insurance policies because they're not insurance, but they're gun owner protection plans. So if you're involved in a situation where you think you have a right to use deadly force and you brandish the weapon or you use the weapon, and it may be self-defense, it may be that it's not self-defense, but either way, you might have to go through a trial and let a jury decide. Your homeowner's insurance and your business insurance isn't going to protect you financially on that claim because those are intentional acts. But there are products out there that are available that are well recognized that for relatively minor amounts of money, as little as about $150 a year, they will at least provide the cost of the defense attorney if it's a incident involving the use of a weapon in self-defense.
Interesting. Good to know. Listen, we're going to take a quick break, John. When we come back, we'll take some phone calls for you, continue our conversation in our next segment right after this. Stay with us.